And we'll move on to the story now of Public Protector Advocate Kholeka Gcaleka briefing the media on her report on the findings into an investigation on the difficulties that gender-based violence victims experience when opening cases at magistrates' courts across the country. Let's take you live to that briefing.
Constituted maladministration and prejudiced her and her family. The evidence obtained by the Public Protector during the investigation indicated that the late Ms. Scorcher visited the Belleville Magistrates Court around midday on the 8th of June 2020 to apply for a protection order against her partner. Her name was placed on the list of complainants in the protection order section of the Belleville Magistrates Court. She was attended to by a clerk at the domestic violence section who gave her an application form and explained to her the process that she had to undertake. The investigation by the Public Protector established that Ms. Scorcher left the Belleville Magistrates Court about an hour later without completing and submitting the application form for further assistance. She was accompanied by Ms. N.G. Dolph, to whom she explained that she did not expect that the process would be so long and that there would be so much to write out. The Public Protector then closed this matter on the basis that we could not find any adverse doing from the part of the officials of the Department of Justice. However, we decided to begin an own initiative investigation looking into the root cause of the administrative challenges to address public complaints regarding the inadequate level of service delivery by the key role players, most specifically the Department of Justice and Constitutional Development, which is the national department that is responsible for the administration of justice and overseeing the courts when dealing with gender-based violence cases. The South African Police Service, which has the constitutional mandate of preventing, combating, investigating crime, and is of the primary agencies of the state responsible for the protection of the public and especially gender-based violence victims as first responders. And the Department of Social Development, which has the constitutional mandate to provide appropriate social assistance for those unable to support themselves and to support and collaborate with other state institutions and other stakeholders in supporting victims of gender-based violence. Based on the analysis of the information, the following issues were considered and investigated: whether the Department of Justice and Constitutional Development did not put adequate measures in place to protect victims of gender-based violence. If so, whether such conduct is improper as envisaged in Section 182(1) of the Constitution and amounts to maladministration in terms of Section 64A(1) of the Public Protector Act. Whether the South African Police Service did not put adequate measures in place to respond to incidents of gender-based violence, and if so, whether such conduct is improper as envisaged in Section 182(1) of the Constitution and amounts to maladministration in terms of Section 64A(1) of the Public Protector Act, and further, whether the Department of Social Development did not put adequate measures in place to support the victims of gender-based violence, and if so, whether such conduct is improper as envisaged in Section 182(1) of the Constitution and amounts to maladministration in terms of Section 64A(1) of the Public Protector Act. Having regard to the evidence, the regulatory framework determining the standard that should have been complied with, the Office of the Public Protector made the following findings. The allegations that the Department of Justice and Constitutional Development did not put adequate measures in place that effectively protect victims of gender-based violence is substantiated. It is based on the following discoveries. The 38 courts inspected by the Public Protector, with the exception of the Point Branch Family Court in KwaZulu-Natal, are not kept in an operational manner that support efficient service delivery as envisaged in Section 41A and 2A and 51D of the Government Immovable Asset Management Act, in that there are old and dilapidated court buildings such as the Magistrates Courts in Ga-Rankuwa, Bloemfontein, Nelspruit, Piet Retief, Kabokweni and East London. Some of the recently renovated courts, such as the Palm Ridge and Umbumbulu, have structural defects in the form of cracks on the walls and leaking roofs. There was inadequate office equipment, such as malfunctioning telephone lines, switchboard and air conditioners, persistent network problems, broken photocopiers, shared computers, for example, at the Magistrates Court in Umlazi, Umbumbulu, Mamelodi, Pretoria, Mzumbe, and Ndwedwe. The courts visited do not have a fully functional integrated case management system, resulting in manual capturing of cases. The integrated case management system is mostly inaccessible or very slow due to network challenges, for example, at Magistrates Court in Umlazi, Umbumbulu, Mamelodi, Mzumbe, and Ndwedwe. There is poor maintenance of existing infrastructure, which is evidenced by cracked walls, leaked roofs, unhygienic ablution facilities, exposed electrical wiring, broken ceilings, doors and windows at magistrates' courts, such as Umbumbulu, Mamelodi, Pretoria, Mzumbe, Ndwedwe, Nelspruit, and Rustenburg. There are incomplete building projects at some magistrates' courts, such as the Mamelodi Court, which has been incomplete for over a period of 10 years. Pretoria, which was burned down in 2010 and has not yet been repaired, in Garankuwa, where the project to repair and renovate was registered with the Department of Public Works and Infrastructure more than 10 years ago, but never commenced. Some courts, for instance, in Mamelodi, Garankuwa, and Vereeniging, did not have waiting areas, which resulted in court users using open spaces, parking areas, thereby exposing court users to weather elements. There is a shortage of water and electricity in some courts, such as Tehiseng in the Free State. Mobile offices being utilized as permanent structures, as for example the magistrates' courts in Mamelodi, Tlhabane, Mkowankowa, Garankuwa, Vereeniging, and Lady Brand. The infrastructural challenges, as outlined above, have a negative impact on efficient and effective service delivery, in that court officials are unable to execute their functions in a conducive working environment. The slow network and lack of electricity leads to delays and inefficiencies in the service that court officials should render to the public. Water shortages and broken air conditioners create an unsafe and unhygienic environment for court officials and court users experience unnecessary delays in receiving services due to the lack of availability of tools of trade such as photocopiers, scanners, computers for court officials. This is in conflict with the provisions of Section 5(1)(d), which imposes an obligation for immovable assets to be kept operational, to function in a manner that supports efficient service delivery, and Section 195(1)(b) of the Constitution, which requires that the efficient, economic, and effective use of resources must be promoted. The various courts visited, except the Point Branch Family Magistrates Court in KwaZulu-Natal, do not have private or sufficient consultation rooms, which is contrary to Section 10 of the Constitution, which states that everyone has inherent dignity and the right to have their dignity respected and protected. This was evidenced from the factual inspections and interviews conducted during this investigation, inter alia relating to the following courts: Pretoria, Garankuwa, Palm Ridge, Rosenville, Uppington, Galashiwe, Motivestad, Bloemfontein, Putadichaba, and Tehiseng. At these courts, it was observed that consultation with victims of GBV takes place in shared court spaces, which is not conducive to confidentiality and privacy. Furthermore, there are human resource capacity constraints at the courts visited which do not support efficient service delivery as envisaged in Section 195(1)(h), which provides that good human resource management and career development practices to maximize human potential must be cultivated. These constraints were evidenced by the following: in some courts, such as Mamelodi, Garankuwa, Palm Ridge, Vereeniging, Johannesburg, Uppington, Rosenville, Pretoria Court, Galashiwe, Botshabelo, Bloemfontein, Putadichaba, Kowankowa, Thohoyandou, and Mahaulegreng were inadequate human resource capacity was found, such as gender-based violence, specialized prosecutors, interpreters, magistrates in rural courts, court clerks and administrators. There's also a lack of assistance being provided to applicants to complete these forms and explain processes to them. Long waiting times and inconsistencies in timeframes according to which protection orders are dealt with across the various courts, which are linked to insufficient capacity. The majority of the courts do not have a proper filing system, nor space. This was evidenced by files scattered on the floor at the various courts inspected. This is in contravention of Part 510, 1A and B of the National Archives of South Africa regulations, which requires that the head of government body shall ensure that all records receive appropriate physical